Good evening. Welcome. It is my great privilege on behalf of the Sonali Chakraborty Foundation to welcome all of you to the 5th Sonali Chakraborty Memorial Lecture. This welcome particularly includes and embraces all our beloved and respected dignitaries on stage, our Reverend Shami Shuparnanandaji Maharaj, Professor Bimal Roy, and our speaker today, Justice Pinaki Chakraborty. I stand corrected, Justice Pinaki Chandra Ghose. I'm sorry, sir. Also a very big welcome to everybody present online as well. Before going any further, this is an earnest request. Please switch off all your cell phones, your mobile phones, or put them on airplane mode or any other mode that will not interfere with the proceedings this evening. A few words about the foundation and today's talk before we move ahead. The Sonali Chakraborty Foundation is a government-registered public charitable trust which aims to extend and perpetuate the benevolence that Sonali Chakraborty epitomized in her life and work. Sonali, apart from holding office of the Additional Excise Commissioner of the Government of West Bengal, was particularly known in her fraternity for her generosity. Sonali had served the Government of West Bengal as a WBCS Group A officer for 25 years before her service was cut short by the only eventuality of mankind. Being amongst the youngest of her batch, which was the batch of 92, she was one of the few female officers in the ranks and always took immense pride in the integrity and righteousness with which she carried out her responsibilities. Apart from her compassion towards associates and people around her, she's still remembered by her colleagues for the remarkable emphasis on very high moral standards and humanity above everything else, even at the cost of personal sacrifice, at times, all with an indelible smile on her face. Sonali began her schooling at the Ramrampur Junior Basic School, a state government-aided primary school on Diamond Harbour Road, that's South 24 Parganas in the district of West Bengal. Sonali made her school very proud by securing a rank in the primary scholarship examination conducted by the government. She graduated with honors in English from Women's Christian College, Kolkata, and later completed her master's in English from Calcutta University in 1991. She qualified at the WBCS examination in Group A in 1992 at the very first attempt. Sonali had a very modest background. Her father, Arun Chakraborty, worked in the Land Revenue Department of the Government of West Bengal, and her mother, Deepti, was a homemaker. To commemorate her indomitable spirit, the foundation wishes to undertake projects which can change the quality of life of the beneficiaries with the focus on underprivileged women. Currently, the foundation is running an interactive computer lab at Ramrampur Junior Basic School. This is for disseminating computer literacy among underprivileged students. The foundation, in collaboration with Women's Christian College, Kolkata, also provides assistance to aspiring candidates for different competitive examinations. For public service, especially to those who are not privileged enough to be able to afford it on their own. We offer training, study materials, regular assessment, and mock tests. The foundation has instituted the annual lecture series on public administration at the Ramakrishna Mission Institute of Culture here to usher in a new thought process for those in the service of the public, which Sonali imbibed to the best of her effort in a dignified manner. Sonali Chakraborty was an ordinary woman and came from a very modest background. She had some extraordinary qualities, however, which any human being can possess, irrespective of the economic background. The Foundation tries to give confidence to such ordinary women. It is a matter of privilege that we are able to organize this lecture in an institution which has the blessings of the apostle of ordinary, yet most extraordinary women, Ma Sharoda. The edited version of the lectures have been compiled into books every year. The previous year's lecture was delivered by Professor Shugato Marjit. The topic was good governance and the informal sector. The printed version of this lecture with a Bengali translation will be released today. May I now request our respected Shami Shuparnanandaji Maharaj to say a few words of introduction about today's topic and to welcome our speaker for today. The topic is Judicial Oversight and Administrative Discretion, a conflict or synergy. I'm sorry, yes, discretion. Stand corrected again. Incidentally, Maharaj inaugurated the Civil Service Study Center in Women's Christian College in 2019, and his blessings have been our strength always. Sir, we request you to speak a few words.
Om Jananing Sharadang Deving Ramakrishnam Jagat Gurum Padapadmitayo Stitva Pranamami Muhurmuhu. First of all, I pray to the Almighty for Sonali Chakraborty's Atma to be resting in peace, eternal peace. You have heard, she had a great life. She could not leave it full. She had to leave this world. We say untimely, but actually her time was ripe for her to go. And we do not stay even for a moment when our time comes to fruition. So there is no lament for her passing away. She was really, Sonali, a golden girl, golden woman. So her son is present here, a really great scholar in the making, and her husband, Nuchiketa, is so devoted that I failed to find out any PR of a husband like him. He has changed his title even, Padavi, just see, and accepted, and to be happy to be called in the title of his wife, Sonali. I have not seen her, but what little things, what little ideas that I formed out of attending 2 or 3 memorial lectures of her from this, pulpit, I really gathered and appreciate her stay on earth. She was extraordinary in that sense. Now, we have in our midst Honorable Justice Pinaki Chandra Ghose. Former Judge Supreme Court of India and the first Lokpal of India. This lecture is devoted to improvement in the public administration. And here is a man from judiciary. And I feel that he is really the most qualified person to give us some hints about how we can make our public administration more effective, more inviting, more challenging, and more serving. He will be speaking on judicial oversight and administrative discretion, a conflict or synergy. The topic itself is rather difficult for us to comprehend. You may feel it. But when translated in Bengali, it becomes a little bit easier, but not in the fullest form. বিচারকের তদারকি বনাম প্রশাসনিক বিবেচনায় স্বাধীনতা দ্বন্দ্ব না সহমর্মিতা না সমন্বয় So I need to say a few things about the way our society is functioning. So we have three distinct organizations in the society to guide us. One is government, another is legislature, and the other is law enforcement agency. একদিকে সরকার আছেন, একদিকে বিচারকরা রয়েছেন, বিচারপতি, বিচার ব্যবস্থাটা পুরো রয়েছে, আর ল এনফোর্সমেন্ট এজেন্সিগুলো আছে, পুলিশ। এই তিনটি প্রতিষ্ঠান সবসময় আমাদের ওয়েলফেয়ারের জন্য, অগমেন্টেশনের জন্য ব্যস্ত। সমাজে সুস্থ পরিবেশ বজায় থাকবে সেই জন্য এই তিনটি ওয়াচ ডগস রয়েছেন, এরা সবাই একসাথে মিলিত হয়ে কাজ করবেন। টপিকটা খুব সোজা, কিন্তু দিস থ্রি ডিপার্টমেন্টস, three organizations, can they work in unison? Can they work in a spirit of cooperation? Do they keep this view most uppermost in their own mind that we exist just to look after the real good of man, real good of humanity or mankind? This is the issue. This is a burning issue. Even in today's newspaper, you might have seen some jarring deviations from the norm that we have been speaking of. It is very, very difficult to keep faith in these three organizations. Very sorry to say. So this judicial oversight the decisions are being given by the judicial department, verdicts we call, and the execution of that verdict, the judgment, will have to be carried out by the police department in consultation with the administration. কিন্তু আসলে কি হচ্ছে ব্যাপারটা? সবাই এরা চাচ্ছেন যে কন্ট্রোল করো, ইন্ডিভিজুয়ালগুলোকে কন্ট্রোল। দেয়ার আইডিয়া ইজ টু কন্ট্রোল দ্য ইন্ডিভিজুয়ালস। Their role is not to create individuals. They're controlling measures they suggest, and they do go for that. Controlling part is resting with the teachers. If the teachers fail to create all these three departments, even if they work in unison, they cannot control perfectly. That is another aspect. Another aspect. So teachers are becoming handicapped. The very recent incident you all remember. Their position has become precarious. They have become the victims of the existence of these three departments. They are working in what sort of uniform proportion we do not know. For what purpose even we do not imagine. বিচারপতি বিচারের রায় দিয়েছেন, এক্সিকিউশন হচ্ছে না সে রায় 20-25 বছর ধরে। সে বিচারপতি সে রায় দিয়ে লাভটা কি? There is no follow-up program, follow-up process even. এটা স্বাভাবিক কথা। And those who are not acting as per the directions and use their own discretion, they need to be punished. But who would do that? Can the legislature do it on its own? A very serious question. And the entire topic is full of such questions needing immediate answers. So, they have asked me, Nuchiketa, Sonali's husband, has asked me to make some observations on the issue, on this topic itself. So I feel I do not have any competence to do that. If I speak more on this, then I will be inviting problems for me. And I know that Honorable Justice Pinaki Chandra Ghose even can deal with the issue with large amount of reservation. So we, the listeners, we have come with high expectation. We have invited a great personality from the law department, and expect much from him. So what positive directions he can point to, we are all going to look for that. We are eagerly waiting for his valued judgment, and I request Honorable Justice Ghose to enlighten us with the issue. With these few things, I welcome Honorable Justice Ghose in our midst this evening. I welcome the members of the family of Sonali Chakraborty, her friends, acquaintances also, and a very limited number of audience who chose to hear something great from the great speaker. Welcome you all. Thank you.
Thank you so much, Maharaj sir, for making these observations, raising questions, and I'm sure all of us here will be pondering over these, and doubtless in the course of today's talk, a lot of light will be shed on these and other issues. But before the talk begins, there is one small, sir, যাবেন না একটা ছোট formal release-er ekta ব্যাপার আছে. We will now release the printed version of last year's lecture titled Good Governance and the Informal Sector. This is the edited and printed version of the talk delivered by Professor Sugat Umarjit last year. So if our dignitaries on the stage would please present the book for all of you. This is just also to inform you that a copy will be available after today's lecture, so when you go, do make sure you get yourself a copy. And now, as is the norm, we will formally introduce our speaker. So, Maharaj sir, আপনাকে request করতে পারি? Introduce him and welcome him on the dais. Thank you, sir.
So, we will now introduce the speaker formally. We will now release the printed version we just released. Last year lecture titled Good Governance and the Informal Sector by Professor Sugat Umarjit. Justice Pinaki Chandra, today's speaker, former judge of the Supreme Court of India and former Chief Justice of Andhra Pradesh High Court, was the first Lokpal of India. A fifth-generation lawyer from a renowned family of lawyers. He handled many important cases, including those involving the Babri Masjid demolition, the disproportionate assets case against J. Joy Lolita, and the ban on Jallikattu. We are privileged to have him amongst us today. Thank you.
Sir. So it's now time for Sir to begin his lecture. We would like to ask him to come on to the mic.
Good evening. I am really grateful to the organizer giving me a chance to come before you and to speak on the subject. Today's subject is Judicial Oversight and Administrative Discretion, a conflict or synergy. At the outset, I must say that the topic for the day revolves around the concept of public administration, the matter of doing it, and the matters relating thereto. Therefore, I shall first speak few words about the public administration. This is really a philosophy with which all of us are very well aware. The concept of public administration is not a modern concept. This is a concept imbibed of our polity from ancient periods. It is as old as human evolution and human civilization. The principles of public administration can be found in the times of Ramayana, Mahabharata, even. We should read, not read. We should study ancient Indian writings, epics, to understand about the concept of a welfare state and good public administration. In one word, to say as to what is public administration, it is working for the happiness and welfare of all in the state. The ruler of the state must endeavor, keeping in his mind that his subjects shall be satisfied with all the needs legitimately required to lead a dignified life and in a harmony with one another in the society. All these rights you will find which have been given by the Constitution of India to the citizen of this country. Indian culture, as we know, always believes in and continues to believe in the idea of goodness, always lays importance on the basic value of life, love, and care for society. That's the reason in Veda, which recites, Loka samasha sukhino bhavantu. May the entire world shall be in happiness. Thus, the public administration encompasses various administrative services that help strengthen and support societies through non-profit, local, state, and federal government roles. It covers labor relation and ethics, legislative relations, public policy management, financial management, and public budgetary processes. Overall, this public services involves the management of organizations associated with social, economic, and political life. Public administration refers to implementing and managing policies, programs, and services by governmental organizations at various levels. It plays a significant role in influencing and shaping aspects of society, including the lives of individuals. Public administration acts as support to individuals in need and ensure that they have a voice in the policy-making process. They also develop strategies that encourage communities to make use of the services that policies provide. This includes interfacing directly with the public to explain regulations and policies. Public administrators shall have to involve themselves in all stages of the policy cycle to make sure that policies are efficiently implemented. These stages include planning, developing, executing, and monitoring. These officials establish regulations of laws and standards such as business practices, environmental regulation, public health, and consumer protection. They shall have to make sure that there are fair, safe, and ethical practices in the private and public sectors. The role of public administration in the economic planning and development is pivotal in fostering economic and social welfare of the people of the country. For example, these policies may focus on areas such as monetary and fiscal policies, investment promotion and industry regulation, employment generation, improvement in educational standards, health standards, and in a way improvement in overall living standards of all the people of the country, irrespective of their class, color, creeds, etc. That's the reason we have seen in the Constitution of India, Article 21 has specifically stated about the right to life. It gives, by that article, the living of a person is nothing but with dignity. Public administration agencies offer support services to businesses, providing incentives and streamlining investment procedures. They also facilitate international trade by promoting exports, reducing trade barriers, and negotiating trade agreements. Public administrators are essentially the ambassadors between the government, public, and private sector organizations and the people. They leverage private sector resources and expertise and ensure public sector accountability and oversight. To summarize, the public administration theory discusses the significance of government, the function of bureaucracy in supportive democratic governments, public affairs, and budgets. The public administrator develops policies, leads the legislature, executes and administers the law, and makes numerous decisions. They issue varied regulations, bylaws, and orders in exercise of the delegated powers. The authority of public administration is very wide. It deals with award, cancel or revoke licenses, sanctions, and can take different actions based on its judgment and subjective satisfaction. In order to effectively and efficiently discharge their onerous responsibilities of rulemaking and regulatory and adjudicatory jurisdiction, they are vested with necessary powers. There has been a systematic manner in which accountability has been demanded from the administrations. This accountability has been sought through different mechanisms in common. The administrative law has tremendously developed, and now it has become more defined as a method in the democratic countries and has transformed into a more recognizable system to the extent that it is now identified as a branch of public law and as a distinct law from constitutional law. This expansion is a direct effect of the expansion of administrative powers and functions. The states have to, and in fact have bestowed, tremendous powers upon the public administrators. Yet the administrative law developed over a period of time to check administrative abuses without unduly obstructing the administrator's ability to carry out its functions efficiently. In a book, Law of Constitution, Dicey, who has popularized the expression rule of law, defines rule of law as the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power, and excludes the existence of arbitrariness of prerogative or arbitrariness in discretionary authority on the part of the government. This principle propounded by him, Mr. Dicey, is that the rule of law is supreme, and to achieve the supremacy of law, compliance of the three principles, that is equality before the law, number two, predominance of legal spirit, number three, court should be free from impartiality and external influence, is essential. However, there is reason to feel sorry. Malice has been substantially afflicted. the decision-making process of the public administration, arbitrariness has crept in the process. Arbitrariness in the context of administrative law means actions taken by government agencies or officials that are not based on reasons, principle, or a valid legal basis, but rather on whims or caprice. To have a quick reference of the examples, they are such as: number a law enforcement agency arresting someone without a valid warrant or legal basis. 2. The government agency denying a permit without a valid reason or following established procedures. Third, a government agency making a decision that is manifestly unreasonable or lacks a rational basis. Next, a government agency fails to invoke the jurisdiction vested in it or exceeds the jurisdiction vested in it or acts without jurisdiction. A government agency may commit an error of law. A government agency may commit an error of fact. The action of the government agency suffers from procedural impropriety. The arbitrariness and abuse of authority in the public administration shall not be tolerated and allowed. The antithesis of the arbitrariness and abuse of authority in the public administration is lack of rule of law. Here the role of the judiciary becomes eminent. We may refer to the ideology propounded by Benjamin Cardozo. His philosophy of law is the role of courts is pivotal in balancing competing considerations. He argued that the judges should not simply apply existing laws blindly, but should also consider the social context and potential consequences of their decisions. He emphasized the importance of social welfare in the judicial process. He believed that judges should strive to create laws that are not only just but also promote the well-being of society. He emphasizes that law is not static and must evolve to meet the needs of society. He believed that judges have a role to play in shaping the law through their decisions, particularly in hard cases where existing legal principles are unclear or inadequate, and that judges should strive to apply the law in a way that is consistent with the values of the legal system. Hence, the first and foremost duty and responsibility of a democratic government is to ensure the protection of the people and their property, and shall maintain public order and promote overall welfare of the public. If the government is strong and full of positive vigor, so would be the people. The ruler must keep foremost in his mind that in the happiness of his people lies his happiness, in their welfare, his welfare, and whatever pleases him alone shall not consider as good, but whatever pleases his people shall consider as good for him. The public administrator shall deliver the goods and services to the people in just and equitable way by taking unbiased, diligent, effective decisions, and hereby maintaining and sustaining the rule of law in the society. When there is no rule of law, the stronger will prevail over the weaker, and there will be anarchy in the society. The people shall have access to the information with respect to the governance, and in a way to say governance shall be inclusive. Thus the public administrator shall be guided by righteousness. This attribute in the public administration shall only ensure social welfare and inclusive development of the society. The basic features of governance are responsiveness of the government, efficiency of the administration, well-being and prosperity of the people, all-round development of the society, good quality of life, ethical uprightness, and economic affluence. In broader terms, this is the governance, and this should be the governance. After attaining independence, India has reaffirmed itself to tread the righteous path and with avowed commitment towards usuring the welfare state, documented how the governance of the state shall be. That is the Constitution of India. The preamble of the Constitution of India reads thus: "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation." The executive is primarily responsible for implementation of the laws. The welfare and development of the nation is dependent on the efficacy, impartiality, diligence, and righteousness of the executive in implementing the laws. As a corollary of righteousness, a dispensation of its responsibility in implementing the laws, the executive can also be said to stand in the pivotal position to best suggest to the legislative body the new laws to be enacted and or suggest amendment to the existing laws with a view to raise to the ever-vibrant society's needs. The manner of functioning of the executive has to be judged, keeping its benign responsibility in mind. Article 73 of the Constitution deals with the extent of executive power of the Union, whereas Article 162 deals with the extent of executive power of the state. These two are analogous provisions, one in relation to the Union and other in relation to the state. Article 73 provides that subject to the provisions of the Constitution, the executive power of the Union shall extend A to the matters with respect to which Parliament has power to make laws, and B to the exercise of such rights, authority, and jurisdiction as are exercisable by the Government of India by virtue of any treaty or agreement. We shall now consider whether the public administration of the nation has been on ideal lines. There have been plethora of grievances raised by the people before the courts of law on various matters, be it violation of basic human rights, violation of fundamental rights, discriminatory treatment, exploitation of men, women, children, and resources, like of effective access to justice. The violations have been on the rise in respect of natural resources and environment also. The ever increase in the human trafficking, contraband and drug trafficking, in spite of stringent regulatory and penal legislations, has far surpassed alarming levels. What is the reason for this sorry state of affairs? What is the reason for this sorry state of affairs? Where is the drawback in ensuring a welfare state? Where is the failure in ensuring good governance? Whether one can say that the rule of law is prevailing in every walk of our life? Are we not aware of illegal mining, for example? Are we not aware of many ills in the society? Whether there are not necessary laws and regulations? Can we wholeheartedly suggest to ourselves that the rule of law is being maintained to the optimum level and the violations and or illegalities or irregularities, if any, are stray here and there? The legislature, executive, and the judiciary have to play their respective roles, taking guidance from the Constitution of India and to uphold the Constitution and the laws. In the process, there are occasions when the judiciary had to interpret the laws enacted by the legislature. There are occasions when the judiciary had to interpret the substantial compliance of the law and procedure by the executive. This power of interpretation is inherent in the Constitution. The Supreme Court of India is ordained to uphold the Constitution and the laws. The case of R.C. Cooper versus Union of India, which is reported in AIR 1970 Supreme Court, page 564, also known as the bank nationalization case, challenged the constitutionality of the Banking Companies Acquisition and Transfer of Undertakings Act of 1969, which nationalized 14 major banks. R.C. Cooper, a shareholder in one of the banks affected, argued that the act violated fundamental rights, particularly the right to property under Article 19(1)(f) and Article 31 of the Indian Constitution. The Honorable Supreme Court struck down the act, finding that the nationalization and unconstitutional violation, which violating Article 31(2) of the Constitution, which requires fair compensation for proper property acquisition. This case explored the balance between state's power to act for public welfare and the constitutional protection of individual rights, particularly the right to property. This case is considered a landmark judgment in Indian constitutional jurisprudence, highlighting the importance of safeguarding individual property rights against arbitrary state action. However, the Constitution, 25th Amendment Act to 1971, was passed to address the ruling in the R.C. Cooper case. The Constitution, 25th Amendment Act 1971, curtailed the fundamental right to property and permitted the acquisition of private property by the government for public use on the payment of compensation, which would be determined by the Parliament and not the courts. The amendment also exempted any law giving effect to Article 39B and C of the directive principles of state policy from judicial review, even if it violated the fundamental rights. The Amendment Act incorporated Article 31C, by virtue of which the laws enacted in pursuance to Article 39B and C are immune from the confines to Article 14, 19, or 31. Thereafter, the Supreme Court, in Keshavananda Bharati vs. State of Kerala, which is reported in 1973-4 Supreme Court Cases 225, is a landmark judgment of Supreme Court of India. This case was filed by Sri Keshavananda Bharati, the head of a Hindu religious mutt in Kerala, challenging the constitutional validity of the 24th, 25th, and 29th Amendments of the Constitution, which sought to curtail the powers of the judiciary and the fundamental rights of citizens. The Supreme Court propounded the basic structure doctrine of the Constitution, which holds that certain fundamental features of the Constitution, such as democracy, secularism, federalism, and the rule of law, cannot be amended by Parliament. The significance of the judgment lies in the fact that it established the doctrine of basic structure of the Constitution by holding that certain fundamental features of the Constitution, such as the supremacy of the Constitution, the rule of law, and the independence of the judiciary, cannot be amended or abrogated by the Parliament through a constitutional amendment, and the power of judicial review is an integral part of the basic structure of the Constitution. This doctrine has served as a check on the power of the Parliament to amend the Constitution and has ensured that the Constitution remains a living document that is responsive to changing times while preserving its fundamental values and principles. Occasion also arose in the Keshavananda Bharati to interpret whether fundamental rights have primacy over the directive principles of state policy, and the Supreme Court of India has held thus. It is relevant in this context to remember that in building up a just social order, it is sometimes imperative that the fundamental rights should be subordinated to directive principles. The makers of the Constitution had the vision of a future where liberty, equality, and justice would be meaningful ideals for every citizen. This is a certain air of unreality when you assume that fundamental rights have any meaningful existence for the starving millions. What boots it to them to be told that they are the proud possessors of the fundamental rights, including the right to acquire, hold, and dispose of property if the society offers them no chance or opportunity to come by these rights? Or what boots it to the beggar in the street to be told that Constitution in its majestic equality holds its scales even and forbids by law both his tribe and the rich to beg in the street, to steal bread or sleep under the bridge. This is not to say that the struggle for a just economic order should be allowed to take priority over the struggle for the more intangible hopes of man's personal self-fulfillment. But in particular context, fundamental freedoms and rights must yield to material and practical needs. Economic goals have an uncontestable claim for priority over ideological ones on the ground that excellence comes only after existence. Many a times thereafter, the Supreme Court of India held in State of Kerala versus N.M. Thomas in the year 1976, where it has specifically stated, in view of the principles adumbrated by this court, it is clear that the directive principles from the fundamental feature and the social consents of the Constitution and the Constitution enjoins upon the state to implement these directive principles. The directives thus provide the policy, the guidelines, and the end of the socio-economic freedom, and Articles 14 and 16 are the means to implement the policy to achieve the ends sought to be promoted by the directive principles. So far as the courts are concerned, where there is no apparent inconsistency between the directive principles contained in Part 4 of the fundamental rights mentioned in Part 3, which in fact supplement each other, there is no difficulty in putting a harmonious construction which advances the subject of the Constitution. Once this basic fact is kept in mind, the interpretation of Articles 14 and 16 and their scope and ambit become as clear as a day. In Minerva Mills versus Union of India, the Supreme Court struck down as unconstitutional Section 4, which aimed to prevent any constitutional amendment from being called in question in any court on any ground, and Section 55 of the Constitution, 42nd Amendment Act, which sought to give precedence to the directive principle of state policy over the fundamental rights of the individuals. The Supreme Court, in the said decision, observed thus, quote, since the Constitution had conferred a limited amending power on the Parliament cannot, under the exercise of that limited power, enlarge that very power into an absolute power. Indeed, a limited amending power is one of the basic features of our Constitution, and therefore the limitations on that power cannot be destroyed. In other words, Parliament cannot, under Article 368, expand its amending power so as to acquire for itself the right to repeal or abrogate the Constitution or to destroy its basic and essential features. The donning of a limited power cannot, be the exercise of that power, convert the limited power into an unlimited one. Unquote. There were few classic cases dealt with by the Supreme Court when occasions arose to sustain the pristine ideals enshrined in the Constitution. Article 37 in Part 4, containing directive principles of state policy, reads thus, quote, application of the principles contained in this part, the provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Unquote. It is obvious that for long after India obtained independence and the Constitution is adopted, the government has not shown serious concern in implementing the directive principles and in making laws and regulations in a manner to promote the objectives envisaged under the directive principles. Under the umbrella of Article 37, the executive was also inept in implementing these principles. The legislature and the executive remained oblivion of the fact that the purport of Article 37 is that the directive principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. To fill this void, the judiciary has proactively gave effect to these principles through the process of statutory interpretation, and while determining the scope and ambit of fundamental rights, the judiciary has chosen to adopt the doctrine of harmonious construction between the fundamental rights and the directive principles, and also considered the directive principles to be relevant in considering the reasonableness of a law from the perspective of fundamental rights. Apart from the directive principles, we have laws governing various facets. For example, we have a number of labor laws which are either not implemented or implemented in a slipshod manner. Economic exploitation and various social evils continue to prevail in spite of many laws in this field. The accountability in public administration is diminishing, and in certain aspects is at a very low ebb. The role of the judiciary in India in respect of checking and promoting good public administration has been enormous. Here we may refer to the case in People's Union for Democratic Rights versus the Union of India. The petitioner is a public interest group. It filed the petition canvassing the plight of the labor employed for the construction of stadia, roads, etc. in connection with Asian Games held in the year 1982, praying the Supreme Court to give directions for compliance of various labor laws. The court accepted the petition and directed that the provisions of the various laws enacted for the benefit of the workmen be strictly observed and implemented. In the said case, the court observed, quote, private interest litigation, which is strategic arm of the legal aid movement and which is intended to bring justice within the reach of the poor masses, who constitute the low visibility area of humanity, is a totally different kind of litigation from the ordinary traditional litigation, which is essentially of an adversary character, where there is a dispute between two litigants parties, one making claim or seeking relief against the other, and that other opposing such claim or resisting such relief. Public interest litigation is brought before the court not for the purpose of enforcing the right of one individual against another, as happens in the case of ordinary litigation, but it is intended to promote and indicate public interest which demands that violations of constitutional or legal rights of large number of people who are poor, ignorant, or in a socially or economically is disadvantaged position should not go unnoticed and unredressed. That would be destructive of the rule of law, which forms one of the essential elements of public interest in any democratic form of government. The above is an example which shows that the void is not the existence of necessary laws, but it is in the implementation and compliance of those laws. When such is the ineptness in the part of the executive, who shall remedy the situation? Here the Supreme Court belled the cat, keeping aside the technicality of loca standi. It observed, quote, but now for the first time the portals of the court are being thrown open to the poor and the downtrodden, the ignorant and illiterate, and their cases are coming before the courts through public interest litigation, which has been made possible by the recent judgment delivered by the court in judges' appointment and transfer cases. Millions of persons belonging to the deprived and vulnerable sections of humanity are looking to the courts for improving their life conditions and making basic human rights meaningful for them. They have been crying for justice, but their cries have so far been in the wilderness. They have been suffering injustice silently with the patience of a rock, without the strength even to shed any tears. The time has now come when the courts must become the courts for the poor and struggling masses of this country." Unquote. In State of Madhya Pradesh versus Thakur Bharat Singh, the Supreme Court observed with respect to the power of judicial review as thus, quote, "Our federal structure is founded on certain fundamental principles. The sovereignty of the people with limited government authority, that is, the government must be conducted in accordance with the will of the majority of the people. The people govern themselves through their representatives, whereas the official agencies of the executive government possess only such powers as have been conferred upon them by the people. There is distribution of powers between the three organs of the state: legislative, executive, and judicial, each organ having some check and balance, direct or indirect, on the other, and the rule of law, which includes judicial review of arbitrary executive actions. In Kehar Singh versus the Union of India, the decision of the Article 72 vis-à-vis the decision of the President and the judicial review upon such a decision and upon considering various earlier decisions, including Maruram versus the Union of India, the court held, quote, "Upon the considerations to which we have adverted, it appears to us clear that the question as to the area of the President's power under Article 72 fails squarely with the judicial domain and can be examined by the court by way of judicial review." Unquote. The executive has no inherent authority of its own, and all of its authorities originate and flow from the law. The concept of rule of law will have no meaning if the executive were not saddled with the task of carrying out their functions in a fair and just way and in accordance with law. This is the foundation for judicial review of administrative action, and that any abuse of authority by the executive shall be subject to judicial review. Furthermore, in Haryana Finance Corporation versus Jawadhabma Oil Mills, this is reported in IR 2022 in Supreme Court 834, the Supreme Court held that the quasi-judicial authorities are also obliged to follow the doctrine of the rule of law and to act fairly. In Indira Nehru Gandhi versus Rajnarayan, reported in IR 1975, Supreme Court 2299, the Supreme Court considered the question whether Article 329 capital A for Clause 4 of the Constitution of India is valid. Article 329A is introduced through 39th constitutional amendment. This article stated that the election of the Prime Minister and Speaker could not be legally challenged in any Indian court. The amendment effectively stripped the Supreme Court of its authority over the Indira Gandhi case. The court held that Parliament cannot amend the Constitution in a way that interferes with its basic structure. This is because the principle of basic structure includes fundamentals of democracy, the rule of law, and the right to a fair hearing. Article 329 capital A was considered against these fundamental principles as it creates unfair distinctions and restricts the ability to challenge election results. Therefore, the court held that Article 329 capital A4 unconstitutional as it infringes the core value of the Constitution. The Supreme Court, in S.P. Gupta versus Union of India, expanded the scope of access to the judiciary for redressal of grievances. In paragraph 17 of the said decision, it has specifically stated, I quote, paragraph 17. It may therefore now be taken as well established that where a legal wrong or a legal injury is caused to a person or to a determinate class of person by reason of violation of any constitutional or legal right or any burden is imposed in contravention of any constitutional or legal provision or without authority of law, or any such legal wrong or legal injury or illegal burden is threatened, and such person or determinate class of persons is by reason of poverty, helplessness, or disability, or socially or economically disadvantaged position, unable to approach the court for relief, any member of the public can maintain an application for an appropriate direction, order, or writ in the High Court under Article 226, and in case of breach of any fundamental right of such person or determinate class of persons in this court, meaning thereby Supreme Court, under Article 32, seeking judicial redress for the legal wrong or injury caused to such person or determinate class of persons. Where the weaker sections of the community are concerned, such as under trial prisoners languishing in jails without a trial, inmates of the protective home in Agra, or horizon workers engaged in road construction in the district of Ajmer, who are living in poverty and destitution, who are barely eking out a miserable existence with their sweat and toil, who are helpless victims of an exploitative society, and who do not have easy access to justice, this court will not insist on a regular writ petition to be filed by the public-spirited individual espousing their cause and seeking relief for them. This court will readily respond even a letter addressed by such individual acting pro bono publico. It is true that there are rules made by the court prescribing the procedure for moving this court for relief under Article 32, and they require various formalities to be gone through by a person seeking to approach this court. But it must not be forgotten that procedure is but a handmaid of justice, and the cause of justice can never be allowed to be thwarted by any procedural technicalities. The court would therefore unhesitatingly and without the slightest qualms of conscience cast aside the technical rules of procedure in the exercise of its dispensing power and treat the letter of the public-minded individual as a writ petition and act upon it. Today, a vast revolution is taking place in the judicial process. The theatre of the law is fast changing, and the problems of the poor are coming to the forefront. The court has to innovate new methods and devise new strategies for the purpose of providing access to justice to large masses of people who are denied their basic human rights and to whom freedom and liberty have no meaning. The only way in which this can be done is by entertaining writ petition and even letters from public-spirited individuals seeking judicial redress for the benefit of persons who have suffered a legal wrong or legal injury, or whose constitutional or legal right has been violated, but who by reason of their poverty or socially or economically disadvantaged position are unable to approach the court for relief. It is in this spirit that the court has been entertaining letters for judicial redress and treating them as writ petitions, and we hope and trust that the high courts of the country will also adopt this proactive, goal-oriented approach. But we must hasten to make it clear that the individual who moves the court for judicial redress in cases of this kind must be acting bona fide with a view to vindicating the cause of justice, and he is acting for personal gain or private gain or out of political motivation or other oblique consideration. The court should not allow itself to be activized at the instance of such person and must reject the application at the threshold, whether to be in the form of a letter addressed to the court or even in the form of a regular writ petition filed in court. We may also point out that as a matter of prudence and not as a rule of law, the court may confine the strategic exercise of jurisdiction to cases where legal, wrong or legal injury is caused to a determinate class or group of persons, or the constitutional or legal right of such determinate class or group of persons is violated, and as far as possible, not entertain cases of individual wrong or injury at the instance of a third party where there is an effective legal aid organization which can take care of such cases. In Hashinara, Khatun versus Home Secretary State of Bihar, a petition came before the Supreme Court for a writ of habeas corpus, bringing to the notice of the court that an alarmingly large number of men and women, including the children, are behind prison bars for years, awaiting trial in courts of law. The court observed thus, it is a crying shame in the judicial system which permits incarceration of men and women for such long periods of time without trial. We are shouting from housetops about the protection and enforcement of human rights. We are talking passionately and eloquently about the maintenance and preservation of basic freedoms, but are we not denying human rights to these nameless persons who are languishing in jails for years for offenses which perhaps they might ultimately be found not to have committed? The court further observed, a procedure which keeps large number of people behind bars without trial for long cannot possibly be regarded as reasonable, just or fair, so as to be in conformity with the requirement of Article 21. It is necessary, therefore, that the law as enacted by the legislature and as administered by the courts must radically change its approach to pretrial detention and ensure reasonable, just and fair procedure which has a creative connotation. Speedy trial is of the essence of criminal justice, and therefore delay in trial by itself constitutes denial of justice. Though speedy trial is not specifically enumerated as a fundamental right, it is implicit in the broad sweep and content of Article 21. Speedy trial, which means reasonable, expeditious trial, is an integral part of the fundamental rights to life and liberty inherent in Article 21. The amplitude of this decision can be seen from the fact that approximately 40,000 under-trial prisoners awaiting trial were released. This decision also provided guidance to the legislature in effective administrative of criminal justice system. We shall further examine the interpretation made by the judiciary in relation to the exercise of power by the executive. In the case of A.K. Kraipak versus Union of India, the Supreme Court considered the point whether the principles of natural justice, which are typically associated with judicial or quasi-judicial functions, should also apply to administrative actions. In that case, one conservator of forests was made acting chief conservator by superseding his senior, and though he was also a member seeking to be considered to the Indian Forest Service, he was made a member of the selection board. The acting chief conservator participated in the selection process. When his rivals were considered and only when his turn had come, he did not participate in the selection board. In the selection list, the acting chief conservator is shown at the top of the list, and his rivals, including his senior, were not shown in the selection list. Such selection notification was challenged under Article 32 of the Constitution of India. The Supreme Court considered the following questions. A. Assuming that the proceedings were administrative proceedings, whether principles of natural justice applied to them. Number 2. Whether there was a violation of such principles of natural justice. Number 3, since the recommendations of the board were first considered by the Home Ministry and the final recommendations were made by the UPSC, whether there was any basis for the petitioner's grievances. Number 4, whether there were grounds for setting aside the selection of all the officers, including those in the junior scales. It is held that the rule of natural justice operate in areas not covered by any law validly made, that is, they do not supplement the law of this land but supplement it only. They are not embodied rules, and their aim is to secure justice and to prevent miscarriage of justice. If that is their purpose, there is no reason why they should not be made applicable to administrative proceeding also. In that case, it is held that there was a conflict between the interest of acting Chief Conservator of Forest and his duty, and he is made the judge of his own cause, and taking into consideration human probabilities and the ordinary course of human conduct, there was reasonable ground for believing that the acting Chief Conservator was likely to have been biased. However, the malice in administration in different forms, such as unreasonableness and arbitrariness and apathy towards good governance, continued in spite of the judiciary doctoring the implementation of the laws as and when it has come to its notice. In this connection, the facts of the case in Maneka Gandhi versus Union of India may be briefly stated. The petitioner was issued a passport under the Passport Act 1967. The petitioner received a letter from the regional passport officer intimating to her that it was decided by the government of India to impound her passport under Section 10(3)(c) of the Act in public interest. The petitioner was required to surrender her passport within 7 days from the receipt of that letter. The petitioner immediately addressed a letter to the regional passport officer requesting him to furnish a copy of the statement of reasons for making the said order. A reply was sent by the government of India stating inter alia that the government decided, in the interest of the general public, not to furnish her copy of the statement of reasons for the making of the order. The petitioner thereupon filed writ petition challenging action of the government in impounding her passport and declining to give reasons for doing so. The contention of the petitioner is that the right to go abroad is part of personal liberty within the meaning of that expression as used in Article 21, and no one can be deprived of this right except according to the procedure prescribed by law, and there is no procedure prescribed by the Passport Act for impounding or revoking a passport, and even if some procedure can be traced in the said Act, it is unreasonable and arbitrary inasmuch as it does not provide for giving an opportunity to the holder of the passport to be heard against the making of the order impounding a passport. In order that a passport may be impounded, public interest must actually exist in present, and mere likelihood of public interest arising in future would be no ground for impounding the passport. The Honorable Supreme Court interpreted Article 21 to the effect that no one shall be deprived of his life or personal liberty except by procedure established by law. And this procedure must be reasonable, fair, and just, and not arbitrary, whimsical, or fanciful, and it is for the court to decide in the exercise of its constitutional power of judicial review whether the deprivation of life or personal liberty in a given case is by procedure which is reasonable, fair, and just, or it is otherwise. If the Supreme Court had not entertained the grievance raised in Maneka Gandhi case, the arbitrary action of the executive should have gone unnoticed, and under the guise of uncontrollable arbitrary power, the arbitrariness on the part of the executive would have gone unabated. If that be the nature of governance, think of a person who cannot approach court of law to seek redressal of grievance. While reiterating the above interpretation in F.C. Mullin versus the administrated Union Territory of Delhi, the Supreme Court observed that the power to order preventive detention of a person shall be exercised with the greatest care and caution, and the courts have to be ever vigilant to see that this power is not abused or misused, inasmuch as the preventive detention is qualitatively different from punitive detention. Article 38(2) of the Constitution envisages that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the national life, and further, that it shall strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst individuals, but also among groups of people residing in different areas or engaged in different vocations. In another decision, in the year 1988, where the Supreme Court alleged regarding handcuffing of a practicing advocate contrary to law while he was being taken to the court after he had been arrested on the charge of a criminal offense. The court observed, thus, every discretionary power vested in the executive should be exercised in a just, reasonable, and fair way. That is the essence of the rule of law. In Gill versus Tejanura is a case wherein the Commissioner of Police Bombay had discretion to refuse to grant a license for any land conveyance which he may consider to be insufficiently sound for the conveyance of the public. Instead of applying this to individual cases, he issued a general order that any Victoria presented for license must be a particular pattern. The High Court of Bombay held that the order as bad as the Commissioner had imposed fitted on his discretion by self-imposed rules of policy. The administrative authority exercising discretionary power must exercise that power by applying its mind to the facts of the case. In exercise of the power under Companies Act, in a matter Barium Chemicals Limited versus Company Law Board, an order of investigation against the petitioner company was passed by the central government, and the central government is empowered to pass such an order if there are circumstances suggesting fraud on the part of the management. The court held by majority on the facts that there are no circumstances, and thus the order passed by the central government suffers from non-application of mind. Cases have come up before the Honorable Supreme Court canvassing disparity in the salary paid to the regularly employed person and the daily rated casual employees. One such case is State of Punjab versus Jagjit Singh and others, which is in 2016 7 SCR, page 350. While adjudicating upon the controversy, took into consideration the fact that the employees in question were rendering the same kind of service which was being rendered by regular employees. While adjudicating upon the controversy, the Supreme Court expressed the view that the denial of wages claimed by the workers in question amounted to exploitation of labor. It was held that the government cannot take advantage of its dominant position and compel any worker to work, even as a casual laborer, on starvation wages. It was pointed out that a casual laborer who had agreed to work on such low wages had done so because he had no other choice. The court opined that it was poverty that it had driven the workers to accept such low wages. The court held that classification of employees into regularly recruited employees and casual employees for the purpose of paying less than the minimum wage payable to employees in the corresponding regular cadets, particularly in the lowest rung in the department where the pay scales were the least, was not tenable. The court also held that the classification of laborers, though discharging the same functions for the purpose of payment of wages at different rates, was not tenable. It was held that such a classification of violative of Article 14 and 16 of the Constitution, besides being opposed to the spirit of Article 7 of the International Covenant on Economic, Social and Cultural Rights, 1966, all state parties to ensure fair wages and equal wages for equal work. Accordingly, the court directed to pay wages to the workmen who were engaged as casual laborers belonging to different categories at rates equivalent to the minimum pay in the pay scales of regularly employed workers in the corresponding cadres, but without any increments. The workers were also held to be entitled to corresponding dearness allowance and additional dearness allowance, if any, payable thereon. It was also directed that whatever other benefits were being extended to casual laborers hitherto before would be continued. There are many social welfare legislations such as Bonded Labor Abolition Act, Minimum Wages Act, Workmen's Compensation Act. However, there have been violations of such laws and there have been exploitation of human labor. In the case of Bandhu Mukti Morcha versus Union of India, a letter was addressed to the court, and by virtue of that letter, the court took up the matter under Article 32 of the Constitution, and the Supreme Court appointed a committee to study of working conditions prevailing in the previous queries within the Faridabad district, with particular reference to violation of provisions of Bonded Labor System Act of 1976 and other acts. And Supreme Court held that the said Article 32 is maintainable. The government of Haryana took the stand that since it has leased out to the queries, so it is for the lessees to comply with the various laws connected with the labor engaged in the queries. The Supreme Court observed that in spite of lease being granted, since the state is the owner of the queries, it is equality, it is the responsibility for compliance of the laws concerning the query, the labor working in those queries. The Supreme Court held in that matter, we are constrained to observe that this argument, quite apart from its invalidity, ill behoves a state government which is committed to the cause of socialism and claims to be striving to ensure social justice to the vulnerable sections of the community. The Supreme Court gave various directions in that matter, and from time to time, that matter was appearing before the court, and the court used to pass an order in the said matter. In a case in Drug Action Forum versus Union of India, in this case, the contention of the petitioner is that the government's policies were not rational and that certain FDCs were not safe or necessary. The Supreme Court considered the matter and they directed the phasing out of fixed dose combination of streptomycin and penicillin injection from the market with the deadline of January 1st, 1997. The case also dealt with other FDCs, including those containing analgin, etc., etc. In this case, Supreme Court played a crucial role in ensuring that the drug regulations should be rational and that unsafe or unnecessary FDCs should be removed from the market. Considering all these aspects of the matter, the Supreme Court has specifically stated that even by the constitutional bench, that state is accountable for ensuring that there is justice, freedom, equality, and fraternity throughout the country. Every person's fundamental rights must be upheld by the state, and the directive principles of state policy must be followed. The courts have defended the people's fundamental rights whenever required against the state's unfair, unreasonable, and unequal acts or actions. In the light of these all facts and these decisions which has been stated by me in this aspect, I cannot restrain myself from referring to Swami Vivekananda in this connection. He considered politics as a consensus endeavor for social change to secure justice and freedom for all, particularly for the most marginalized ones, and that the necessary precondition for doing such politics is renunciation of one's self-interest for the interest of many. In that sense, it was a moral and spiritual enterprise. He believed, I quote, "The basis of all systems, social or political, rests upon the goodness of men. No nation is great or good because Parliament enacts this or that, but because its men are great and good." He believed, unquote, he believed that people should be motivated to believe that in the interest of one's own nation is one's own interest, in the well-being of one's own nation is one's own well-being. The methods of action of the Ramakrishna Mission, founded by Swami Vivekananda in 1897, included to train men so as to make them competent to teach such knowledge or science as are conducive to the material and spiritual welfare of the masses. B. To promote and encourage arts and industries. He left guidelines on many important aspects of organizational affairs, such as the question of leadership, the attitudes, motivation, and exposure of the workers, effective division of labor, issues related to accountability, transparency, methods of resource mobilization, democratization of the decision-making process, and many related subjects. Instead of merely doing out to the poor, he was in favor of enabling people to claim their rightful positions in society. In his words, quote, "My whole ambition in life is to set in motion a machinery which will bring noble ideas to the door of everybody and then let men and women settle their own fate. If every stakeholder in building up a welfare India cherishes the above philosophy of Swami Vivekananda in his heart and soul, I am sure our country will blossom as a welfare state." Thank you. Thank you to all.
I think you'll all agree that we've just been listening to a most enthralling, enriching, and enlightening exploration of the very important topic that was set for this evening's lecture. That is a talk on judicial oversight and administrative discretion. In fact, you will also agree that possibly few people could be more qualified than our speaker today. Even so, the depth of Sir's knowledge and the width and breadth of his experience put together in this marvelous and rousing discussion, I'm sure has left most of us not just breathless, but maybe also speechless. However, today's program schedule does make space for some concluding comments and then a formal vote of thanks. And so I will request on behalf of the Sonali Chakraborty Foundation, Sir Bimal Roy sir, to please come and make the concluding comments and deliver the vote of thanks.
I think my task is only to offer the vote of thanks. So my sincere and heartfelt thanks to Pinaki Da, or Justice Pinaki Chandra Ghose. I'm using our Ramakrishna Mission culture to address all the elders by Dada or Dadu. So I cannot call Pinaki Da Dadu, so it's Pinaki Da. Then we are obliged to Shamsuparnanandaji, our beloved Shottoda, for hosting such an important event in such a grandeur. And then, of course, the foundation, all the people in the foundation who worked behind it. And finally, all of you who attended to make this program a success. Thank you all.